Hello, and welcome. I'm Torres-Spelliscy, and this is 5 Minutes with the Professor. The topic for this week's 5 Minutes with the Professor will be how the Constitution applies to business. Your text goes into great detail about the constitutional structure of the United States, the constitutional basis for the regulation of business, and individual rights. I would suggest that you read it carefully. As a business person, you will likely interact with the government with respect to regulations, taxes, employment and labor, as well as intellectual property and many other things. All of those powers are derived directly or indirectly from the Constitution. In this podcast, I want to focus on one particular constitutional right that belongs to business, and that is commercial speech. First, let me clear up a common misunderstanding. Your constitutional rights run against the government, not your fellow citizens. Let me be clear. You do not have a First Amendment right against Facebook or Google. Twitter can suspend your account and you do not have a constitutional complaint. YouTube can take down your videos and they are not violating your right to free speech. You do not have a First Amendment right to say whatever you want in a restaurant, in a business, or in someone else's home. Your constitutional rights to free speech only guarantee that the government cannot tell you what to say, in most circumstances. Which brings us to the second key point. Your constitutional rights are not inviolable. The way the Supreme Court has interpreted our Constitution is that a citizen's rights are not to be violated unless the government has a good reason and does so in a reasonable fashion. And how good that reason has to be depends on the right being violated. This is referred to as a standard of review. If the right being violated is a fundamental right, or the law is based on a suspect classification, race, religion, national origin, the government must show a compelling state interest, that the law is narrowly tailored to meet that interest, and that it is using the least restrictive means to achieve that interest. This is called strict scrutiny. Few government policies survive strict scrutiny review. In cases of state actions discriminating on gender, in commercial speech, and/or in content-neutral regulations of speech, the courts apply a more lenient standard, known as intermediate scrutiny, which requires the government to demonstrate that the law or policy being challenged furthers an important government interest by means that are substantially related to that interest. For other rights, the government must only show that the policy is rationally related to a legitimate government interest. This is the easiest standard of review for the government to pass and is referred to as rational basis. Now, the idea that a corporation is a legal person and therefore has legal rights is one that has long been accepted in American jurisprudence. Wait, how are corporations people? Well, in legal parlance, a person means both artificial and natural persons. An artificial person is an entity that exists solely under the law, like a corporation. If a law wants to limit its application to actual people, it will usually refer to natural persons. But where did this admittedly ridiculous distinction come from? To answer that, we have to look back to some historical figures. The first place the idea that a corporation is a person under the law appears to have been written down was in the writings of Pope Innocent IV, who was writing in the 13th century. He appears to have adopted the idea from parts of Roman law, so it is at this point that the idea of a corporate person really emerged. But how did it get into U.S. law? The story is actually a little sordid and involves a powerful and devious lawyer and a colorful Supreme Court justice, former Senator Roscoe Conkling and Justice Stephen Field, with an honorable mention to J.C. Bancroft Davis, the Supreme Court reporter. Roscoe Conkling was a former U.S. Senator who was present during the drafting of the 14th Amendment. After leaving the Senate, he started a lucrative law practice, so lucrative that he turned down a lifetime appointment to the Supreme Court twice. In the years following the adoption of the 14th Amendment, many corporations began to clamor to have their corporate forms recognized as a person under the 14th Amendment. Many of these corporations were railroads, and one of these was Conkling's client, the Southern Pacific Railroad. During the argument in the case, Conkling claimed that when drafting the 14th Amendment, the drafters had purposely changed the wording from citizen to person in order to, Conkling told the court, include corporations. Conkling produced a diary purporting to prove that fact. The only problem? It was all a lie. Now, Southern Pacific would actually end up settling that particular case, but in a few short years they were back again with the same issue. Are corporations persons? The Supreme Court tried to duck the issue and decided the case on other grounds. This made one justice, Justice Stephen Field, very grumpy. You see, Field was an advisor to the owner of the Southern Pacific Railroad and had even advised on legal strategy for this exact case. But the story didn't end there. At this time, the Supreme Court's decisions were published in a volume of books, edited by an administrator for the court called the Reporter of Decisions. Before each decision, the reporter would draft a summary of the key parts of the decision called headnotes. These were not written by the actual members of the Supreme Court. And here is where we meet Mr. J.C. Bancroft Davis, who was the court's reporter in the 1880s. Importantly, he was also the president of a railroad company in New York. In the headnotes to the case, Bancroft wrote that the justices had declared that corporations are people too, despite the fact that in the written opinion, the justices had explicitly refused to address that question. According to Bancroft's notes, before argument began, Chief Justice Waite addressed the court, saying the justices were in agreement that corporations have rights. This language, however, never appears in the opinion. Whether this act of Bancroft was nefarious, an honest mistake, or an honest statement of what the Chief Justice had said orally, we'll never know. But it is all that Field needed to pursue his agenda. Shortly after, in an unrelated case, Fields would summarily conclude, corporations are persons within the meaning of the 14th Amendment. It was so held in Santa Clara County versus Southern Pacific Railroad. From there on, the case would be cited again and again for this proposition, despite the fact that the conclusion never appears in the court's opinion. The doctrine of commercial speech was not developed by the U.S. Supreme Court until the 1970s. Prior to this, commercial speech was not considered to be within the protections of the First Amendment. In landmark cases in the 1970s, the court reversed this position, holding that our question is whether the speech which does no more than propose a commercial transaction is so removed from any exposition of ideas and from truth, science, morality, and arts in general, in its diffusion of liberal sentiments on the administration of government, that it lacks all protection. Our answer is that it is not. The court went on, in concluding that commercial speech, like other varieties, is protected, we of course do not hold that it can never be regulated in any way. Some forms of commercial speech regulation are surely permissible. In particular, the court found that advertising that is false, deceptive, or misleading can be regulated without abridging a company's rights. This is key for a business to know and understand when conducting advertising campaigns. You are not protected by the First Amendment if you make false or misleading claims, and in those circumstances, the government may punish you for false advertising. This is what happened to Gwyneth Paltrow's lifestyle product firm, Goop, in 2018. The complaint against Goop alleges that they were falsely claiming that some of their products had certain medical benefits, when such benefits were never proven. Goop was sued by the state of California, where it is headquartered, and ended up paying about $150,000 in fines, as well as being subject to a 5-year injunction with respect to their advertising content. Ms. Paltrow's defense? We didn't understand that you can't make certain claims. We just thought we were like writing a blog. Paltrow said that Goop has now hired a regulatory team and in-house scientists and lawyers to make sure that they do not run afoul of the law again. Not only can you not make false or misleading claims, If your product is dangerous, the government can compel you to warn consumers about the use of the product. For example, since the 1960s, the U.S. government has required that tobacco companies place warnings on their products, indicating that their use may be hazardous to health. A 2009 law, the Family Smoking and Prevention and Tobacco Control Act, requires that the FDA create graphic labels, like we see in other countries. But a lawsuit by the tobacco companies saying that the new labels go too far with respect to compelled speech was filed, and lower courts were split. Some ruled the new warnings were unconstitutional, whereas others found the new warnings constitutional. The government did not seek further review and agreed to redraft the warnings. The FDA has been reviewing and researching the warnings ever since. In September 2018, a district court in Massachusetts ordered the FDA to speed up the process, so we may still get graphic warnings on cigarette packages. So in summary, as a corporation, you have a constitutional right to advertise your goods to the public. The primary limitation is that the advertisement must not be misleading or deceptive. Further, if your product is dangerous, you may have to disclose that and provide consumers with warnings. Well, that's it for this week's podcast. Go on to read the text and complete the assignments for this week, and I will see you on the discussion boards.